Hello, HCCLA. I am not Murray Newman.
Thank goodness.
I know, everyone's cheering at home right now. We're not missing you, Murray. Maybe a little bit, I don't know. I'm still working on being your fifth ex-wife, so there's that. I'm missing that part. But we have a great show here today because we have Shannon Davis joining us.
Thank you, Jackie.
And I'm so excited to have you on the show because I know that you are sarcastically witty.
Itty bitty.
And I speak sarcastic wit.
It is my love language.
So you were telling us about a prank in the DA's office.
Right. So I decided to wait. And when the eval time came, I don't know, maybe a month, 2 months later, I can't remember. I called the guy into the office. I'd never said word one about him and told the other party that, thought I was hitting on him, don't say a word. This is going to be epic. So I tell him to sit down, close the door, and I said, I got your exit eval. Here you go, read away. And you could just see the steam building, the tension building, trying to figure out, what have I done to piss him off so badly? And how hard am I going to hit him for doing this and tanking my career?
Whoa.
And you can see the color just changing. And as he looks up and the eyes are steaming and he's trying to figure out what to say, I said, "Oh, Jimmy, the cut of your pants looks so sexy." And he immediately knew it and his head just dropped and was like, "Oh my God, you got me." And I was like, "Here's your real one. Congratulations, man." I don't think we could get away with that nowadays. Just saying.
No, I don't think so. Not with all the HR complaints that people just love to file, right?
Yeah.
So I'm excited to have you on the show because you recently had a big win in the 179th.
I did. Thank you very much.
And, it's hard to get a big win on a sexual assault case.
That it is. In my career as a defense lawyer, I have only won 2 of them across the board. And I have to phrase it that way because the other one was a court-martial, and in federal court, because they hit you with a bunch of charges that you're defending at once, that guy had 5 charges. And it's not uncommon to beat a couple of them but still get convicted on others, but to beat the entire charge sheet doesn't often happen. And so that one was a pretty good feeling too.
So why do you think sexual assault cases are so difficult to defend against?
The average Joe just does not want to believe that a child would make something up, which is funny because everybody out there who's a parent, I'm sure you included, when people say, "Do kids lie?" they all laugh because they know kids lie.
Absolutely.
But they can't wrap their heads around the idea that somebody would lie about something so seriously. And so it's an uphill battle from there. All of them want, and I say all of them, but most jurors, prospective jurors in voir dire, just want to believe that kids will tell the truth when they're talking about this stuff. And that is an almost insurmountable prejudice that we have going against us as defense lawyers to try and overcome. So I'm always looking for new and different ways to try and expose that and get rid of those folks.
Now, you also have a different perspective because you used to prosecute them as well.
Yes, I was a prosecutor for a little over 16 years, and 5.5 of that was exclusively doing child sex abuse cases.
And when did you leave the district attorney's office?
Summer 2014.
Freedom, right?
For the past decade.
You have any plans to go back?
No.
But there's about to be a new administration soon.
Okay, this is me caring. No, you couldn't pay me enough for it. Besides, there's no way I would be floating the mortgage on the new office.
I understand. I have been running around trying to get some of the former prosecutors who were, very decent to consider going back to the office. What do you think about that?
I think it is long overdue. I think that there is a serious issue with institutional knowledge that has been lost.
Yeah.
And right now it's kind of the blind leading the blind. So it would be nice to see some of those folks go back.
Now, I know I'm surprising you a little bit, but I think you're accustomed to it because you're a criminal defense lawyer, so you got to pivot. But there are sort of two sides to this coin. On the one hand, criminal defense is sort of winning, right? We're winning we're getting a lot of not guilties and that sort of thing. We're going to trial. So I don't know. In some respects, it's easier being a criminal defense attorney. If what happens is we get real experience back in the office, are you concerned since you're going to remain a criminal defense attorney, are you concerned that the prosecutors may become really, really super good now that they know what they're doing?
Not really. I mean, I don't want to misquote somebody, so I'm not even going to attribute the originator of the quote. It's just not me. So the quote essentially goes, if everybody does their job, the system works great. And the problem as I see right now with the system being broken is you're getting too many dog-do charges that are filed that should never have been filed, that should have been screened by somebody that knew what the heck they were doing. And then the people that are working those cases up, once they are filed, need to have the backing of the elected to have some discretion and do the right thing. I'm just seeing too much of people burying their heads in the sand or acting like a cat covering up poop, trying to make sure that nobody notices anything and maybe just go on to their next assignment before something happens. I mean, quite frankly, if you have a good intake system and they're weeding out the trash right then and there, you don't have as many bad charges that are coming in. If you've got prosecutors that have the ability and the backing of the elected to do their job and do the right thing instead of being too scared to do anything, then you're not going to have overloaded courts. And if you don't have overloaded courts, you don't have illegally created courts like ERD or the need for all the new district courts or associate judges or any of that kind of mess. I just don't see the backlog that they keep talking about.
Well, I don't know. To some extent, I think there is a backlog, but the backlog is because they've got trash cases that they refuse to dump.
That's what I mean. It's not caused by a natural disaster. We aren't talking about the fact that we had a pandemic. We're not talking about the fact that we had a flood that closed down the courthouse. Right now, we're just talking about lousy cases that have been hanging around for far too long that they should have cut bait a long time ago.
So when you run into a trash case that they refuse to dismiss, what are you forced to do?
Let's try it. Put up or shut up.
And even then, that takes longer, right?
It does. And depending upon what court you're in, you may go quickly, you may not go quickly. Then they start playing games like, oh, we're going to send it to ERD so that it's going to be heard by somebody that was voted out last cycle and somebody who actually has skin in the game because they were elected. I don't know. It's a sore subject for me because I disagree with it on many levels.
I can't tell. Okay, so
Busted.
Your sexual assault case in the 179th.
Yes.
Tell us about it.
I was appointed on the case in February of 2020. I was not the first lawyer on it. The first lawyer had only had the case maybe 3 or 4 months or thereabouts, but he retired, and so his cases went back into rotation, and I got it. At the time that I saw him, my client was using a cane to get around because he had Parkinson's. In working up the case, and of course as time went on, the Parkinson's began to get worse and worse and worse, and by the time we had both trial numbers 1 and 2, for the most part he was confined to a wheelchair. Very difficult time getting around and walking. And the alleged victim in the case was his biological daughter. There were some family court issues that came out. Essentially, my client did not show the best judgment in that he left his wife and daughter and essentially set up shop and made a new family with another woman, had kids with her.
You mean that created a problem in the marriage?
Just a tad, yes. He had walked out on the wife for sure. The daughter, not as much and not as to an extent, but I'm sure that there was some tension because of that.
How old was the daughter at the time of the walkout?
At the time of the walkout, let's see. I totally forgot that. She had to have been
A teenager?
no, she was 6 or 8. He was sort of an absentee father for a while, and it took a number of years before they actually got divorced. I mean, he had already been living with and had children with this new woman, and it wasn't until 2015 that the divorce got finalized. I want to say he moved out in like 2008 or 2009, something like that. Anyway, when I checked out the divorce decree, one of the things that caused bells and whistles to go off in my mind was that the ex-wife got 3 years of spousal support, which I don't do family law.
That's unusual.
Ever.
That's unusual in Texas, though.
Yes, I mean, that was all I remembered from marital property in law school was just that, yeah, we're Texas, we're community property. You don't get that.
It's also a no-fault divorce state, right?
Right, but she alleged in the petition that there was adultery and it was a default divorce. He didn't show, he didn't contest it, nothing, and she got 3 years of spousal support. And I just found it very peculiar that that spousal support ran out in October of 18, and gee whiz, September of 18 was when the outcry was made.
Whoa, 1 month before.
And I couldn't find a prosecutor to think, that's mighty curious.
So, okay, let's back up a little bit because maybe we have some people that aren't lawyers or don't do sex cases.
Okay.
Why is that important to you?
Well, what's important to me is, in my experience, there are only really 2 defenses ever to a sexual assault of a child case. One of them is didn't do it, and there are many permutations of how you get there. The other one is I did it, but. And usually that is when you're talking about the Romeo and Juliet, maybe just outside the 3-year or 5-year or whatever the case may be, depending upon the charge that the DA is looking at, grace period for Romeo and Juliet to kick in. But
So, I didn't get it. You said there are many permutations, but
I didn't do it, yes.
But essentially what you're saying is the child is lying.
Not necessarily. It would be a little too easy to say that the child is lying, mainly because, and this is one that I have tried to incorporate in some way, shape, or form, although not every expert has read up on it. Elizabeth Loftus is a psychologist in Southern California that is most known for some of her grad students in doing the Lost in the Mall study. And ever since I got introduced to that and started reading up on it and those kinds of things, there is such a thing as not realizing that you are lying. And sometimes you can do a soft sell on something like that to a jury instead of just liar, liar, pants on fire. It's, look, Mama has told her that this happened so many times. She really believes it.
And
if you hooked her up to a poly, she'd believe it.
And that goes to suggestibility of children.
Correct.
Which is why we worry about how children are interviewed in the first place, right?
That is correct.
There was a forensic interview in this case?
There were a number of interviews, but yes, there was a forensic interview.
Okay. Can you explain to the audience why we do forensic, or why we would want a forensic interview?
Yes. Allegedly. Forensic interviewers have specialized training for the correct way to interview child victims in different cases.
I gotta say, allegedly is literally a criminal defense lawyer's favorite word. Can you
Not
think of
guilty
any?
is my favorite, but...
That's 2 words, though.
That is. I can hyphenate it. I've seen it as a vanity plate. Isn't that Grant's car? Okay.
Where are we going to call out Grant?
Hey, we love you, Grant.
We do. Yeah, that's true.
But
Okay, so
you
were
they're
explaining forensic
supposed
interview.
right. They're supposed to have training so that they are not making suggestions to the children. The idea is that they're letting the child talk. And if you just think about what we normally do when we're in the courtroom, a prosecutor does direct examination. They're supposed to say, "What is your name?" for a question. Whereas leading questions, like we defense lawyers would ask, would be, "You're Jackie Carpenter, right?"
I think so. Some days,
Yes.
maybe.
When you're not being Murray Newman's future fifth ex-wife.
Exactly. I much prefer that.
But
As a matter of fact, I think we need to change my label to, instead of Jackie Carpenter, Murray
Mark?
Newman's future ex-wife. You can make that happen, right, Mark?
oh yeah.
Oh, yeah.
Anywho, so they're supposed to have this specialized training so that they aren't really interfering. And when they video record these forensic interviews, it's sort of like, I don't know, peeling off individual skin layers of an onion to try and get to the truth in the middle. But some forensic interviewers are better than others. Sometimes things are suggested. Other times you have really horrific forensic interviews. The last sexual assault trial that I had, there was actually a civil defense lawyer or a civil plaintiff's lawyer sitting in the room next to her client, participating in said interview, asking questions. Are we preparing a civil case or are we actually prosecuting a criminal one? I don't know.
Wow.
But
That's bias right there.
just a little bit. But in this case, the important takeaway from the forensic interview was that she said it only happened one time. And she also described no grooming. So as I'm going through the initial evidence that is turned over to me with discovery and I'm seeing this stuff, I'm going, why are they not having problems with this? Usually grooming is present in some way, shape, or form.
It's
Whether-
also very easy to prove up because it doesn't take much.
Right, special gifts, whatever the case may
Did you
be.
feed the kid?
Yeah. Well, and of course the DA.
I'm a parent. Of course I fed the kid. I would be facing CPS charges if I didn't, but still, grooming is easy.
That's correct.
You buy a gift for a child, they consider that grooming.
Well, and sometimes they try and pigeonhole it in there to try and say, "Oh, this is grooming. This is grooming." When it's like, no, it's called being a parent. Okay.
You gave your child gummies? Gummy snacks, not, not.
Yes, no,
the gummies,
not Delta 8. Thank you very much. These are the little Haribo ones. Sometimes they make worms.
I realized how it sounded after it came out. It's like, wait a minute, that might, no, we can't do that.
Yeah, but this one just blew my mind because there was no evidence of grooming. It was just like one day, all of a sudden, Dad just turned on a switch and was like, "Let's molest daughter."
Whoa.
And it was a one-time incident, according to her.
Which is mostly rare if you have frequent access to a child.
Right. So, I mean, there's, if I remember correctly, it was the standard divorce decree, first, third, and fifth weekend of the month, and every 1 month in the summer, that kind of thing. And so they would make arrangements for her to see it. And of course, he had new kids by his new wife, and they would come over. It just didn't make sense to me that one day, all of a sudden, I'm just going to drop everything and to heck with it. I'm gonna have sex with my daughter. I don't know how you get there, but when you have, Mama did a walk-in report to the police, so there was no 911. It was just her going to a substation. So we had that report. We then had her going to the hospital. They didn't do a full-on sexual assault examination because of the delayed reporting nature, but those records, again, one-time incident, penile vaginal penetration. We had the forensic interview, one-time incident, penile vaginal penetration. We had the CPS records where they went and interviewed her. Again, one time only, penile vaginal penetration. Fast forward about a year, and 2 detectives went and interviewed her at school. And now all of a sudden it happened 4 times.
Whoa.
And she starts giving details about those.
So has she been to therapy in between?
They said that she did, but I didn't see anything to substantiate that. They didn't turn over any records. They did give school records, and the school records were, I mean, there was nothing in the school records to indicate that she had talked to a counselor or was having trouble in school. I mean, her grades were consistent the whole way through. But we just had this second interview at the school with the police. And one of the funny things about that interview that kind of raised some suspicion for me was one of the detectives was not regular child abuse. She apparently was on loan from homicide so that I guess they could give her some more exposure. She wasn't believing it. She was having some of the same issues that I was, and she was challenging the complainant, saying, "Now, this doesn't make sense to me. What do you tell me about this?" I mean, I'm sure somebody listened to it later and said, "You get her out of child abuse and never let her do that again." But
I mean, clearly what they're taught in child abuse is whatever the child says, we just take as truth and run with it.
well, take a good look at some of the mission statements for children's assessment centers all over. You're not supposed to challenge the child, which just is mind-boggling to me. Mm-hmm. But they don't. And if you try to cross them on that, they'll say, "Oh, no, that's not what we do." Right, okay.
I am curious as to why, after a year, they sent these 2 detectives to do the interview in the first place. Normally, you do the forensic interview in order to stop the child from continuously being re-victimized.
I honestly have no idea why they did it in this case. The only thing I can think of is because my client, he did give an initial telephonic interview where he just said, "I don't know what the hell you're talking about. I didn't do this." And he also, of course, gave me the great thing. He goes, "Her mother probably put her up to it. Do you know how angry that woman is?"
I mean, she had every reason to be angry.
Yes, and I get it. He shouldn't have cheated. There are other ways to have ended that relationship.
And there are also other ways to express your anger than utilizing a child.
Well, and it also got kind of interesting because after the breakup, she decided to get rather learned in the law and got herself an associate's degree in criminal justice, and then decided to go to work or get her paralegal certification and go to work for a district attorney's office in another state.
Oh.
And
the plot thickens.
oh, yes, it does. In the second trial, I made use of social media and had a field day with it on that. But
Okay, so in the first trial.
okay, the first trial took place about 2 years ago. It wound up being a hung jury and not in my favor. It was a hung jury, 8 for guilty, 4 for not guilty, which is, I'm sure, why the DA's office was chomping at the bit to try it again, because they thought, "Oh, this was just a fluke. We'll do a better job on voir dire, etc."
Did you talk to the jury afterwards?
I did. I was very disappointed in talking to them. The majority of them went in there with that prejudice that I had not identified, that they're just going to believe the kid. And the ones that said not guilty all felt like something had happened. They just weren't sure what. And they at least understood what their duty was.
That's a big point, but go ahead.
So that was my takeaway, was I have got to do a better job in voir dire of identifying the people that are going to tell you what they think you want to hear, which is, "Oh yeah, I can be fair," when really and truly they are in fact going to believe what a kid says about sex abuse just because they're a kid. So my second trial, I learned from that, and I actually turned that into a challenge for cause.
So I want you to explain that a little bit more.
Okay, the way that we conduct voir dire jury selection is the judge will talk to the prospective jurors, the DA will talk to the prospective jurors, the defense attorney will talk to the prospective jurors, and ask them questions about various things. We can't necessarily talk about the facts of the case, but we can give hypotheticals that might somehow be relevant to the case. So the way that I posed the question, and I figured if it's good for the goose, it's good for the gander. You know, DAs always want to talk about the one witness rule. Oh, if this one witness testifies to every element of the case and you believe that witness beyond a reasonable doubt, you have to follow the law and find this person guilty. Or are you going to raise my burden and require something else?
And so it's interesting, raise my burden when they have the absolute highest burden
Yes.
that there could possibly exist.
Correct.
Beyond a reasonable doubt.
Right. So I twisted that question for my use on this thing, and I just said, okay, because I'd given them some examples of why somebody might lie or why somebody might have motive to lie, those kinds of things, and then talk about some of my own failed relationships. And people always get along after divorce, right? Or how about a bad breakup? We always get along afterwards, right?
Are you telling me you don't always get along after a bad breakup?
Oh, yeah, right.
I'm sure you have a lot of stories to tell on that front.
I'd like to phone a friend. Yeah, so but
That is the wrong show.
yeah, I think so. But that was how I at least tried to preface that stuff to lay the groundwork for the prospective jurors, so that when I asked the question, and I'm like, okay, are you going to believe a child reporting child sex abuse just because they're a child? And the prosecutors tried to argue that they didn't really say that it was an improper commitment question under Standifer. Instead, what they tried to argue was that it did not lead for recognizable grounds as challenge for cause. And I had to look at the judge and say, how does not being able to follow the law equate to that? And because I had so many of those jurors that answered that way, and she was seeing the panel look like it was going to get busted, she was very hesitant to do that. But I stood my ground and I said, no, get number 14 up here. Let's have a chat with him. And no matter how many ways the judge asked it, when it came down to that question, he just said, no, I'm going to believe the child that does that. So with that as the very first one.
I know the audience is now going, what court were you in again?
I was in the 179th District Court, which is Judge Anna Martinez. And she realized that as soon as he stood his ground and said that if she didn't make inquiries of the remainder of those that hadn't struck themselves for some other reason, it might equate to reversible error. Mm-hmm. So we did wind up having to call about 20 people. And that's scary. 20 out of 60 people who are gonna believe a kid just because they say it happened to me. Mm-hmm. And most of them, to their credit, stuck to their original answer. There were a couple of people that decided to hedge their bets, and they got cute, realizing, oh, wait, if I change my answer, I get to stay on this panel. I'm like, peremptory on you next. Mm. But probably 15 of the 20 stuck to their guns and said, if a kid says it, I'm going to believe it. And the judge properly struck those people for cause. And the ones that changed their answer, they'd already showed their true colors to me, so I was going to burn my peremptories on them. Okay.
So did you end up having to ask for extra peremptories?
I did not. Because they had covered their bases well enough, I knew that it would be a fruitless effort, and Dad always gave me the advice, dig where the ground is soft. So I wasn't going to be making a big deal about that right then and there when I thought they had protected and insulated themselves enough from calling it a valid challenge for cause that I wasn't going to get anywhere with it.
But nevertheless, you still managed to identify these jurors.
That is correct.
Which was the whole entire point of the question.
Yes, if I can get them gone for cause, that's great. But if I can't get them gone for cause, at least I have identified the wackos that I do not want on my jury because they have already told us that they can't be fair. Mm. And so that was how that went down. And I've actually never quite phrased it that way in
wackos?
A case before. No, not wackos. No, are you going to believe a kid just because they're a kid because of this? And
You do have colorful language.
I do. Paint a picture with words. That's what I learned.
Yeah.
Sometimes that picture can be very nasty, but
Don't worry, we're not going to do that today.
yes, yes, yes.
So, between the first trial and the second trial, what's the time difference? How long in between trials?
Nearly, it was roughly 20 months.
Okay.
So it was quite a bit of time. In fact, because of how backlogged the trial docket was in that court, everybody who was on the trial docket sort of got a notice that at the start of the new year, the judge was going to start a new procedure. She was going to prioritize certain cases and that sort of thing as to when they would appear on the trial docket. And I really wasn't having any part of that. I was not very happy to hear that because we'd been waiting for quite some time. And I really got the feeling that the DA's office had no intention of trying it again. They just didn't want to let this guy go because the word no is an anathema to them. So instead, I filed a motion for speedy trial. She told me, well, we can't rule on that. I said, the heck we can't, Judge. We need to have that ruled on right here and now. State's been dragging their feet. Back over the summer, I was ready to go to trial. They were not because, oh yes, our child victim apparently had a complicated pregnancy. So they got yet another mulligan because their complainant got pregnant, and believe it or not, when we tried it again last month, she was already pregnant again.
So,
not by my client.
Allegedly.
But anyway, I was not a happy camper with how long things had taken.
How old was she when she testified?
I believe this last go round she was 20.
Okay. And then, so the time before that, she would have been about 19.
18. So, but the speedy trial motion was denied, but it did at least get me what I was looking for, which was one of the earlier trial dates to start off the year. There was a little bit of back and forth negotiation with the state. They kept trying to sell my guy on a deferred, and he just said, I didn't do a damn thing. Why would I sign up to be a registered sex offender for the rest of my life?
Were they trying to reduce it?
No, they were offering a deferred, and to my guy's credit, he stood his ground and said, no, I'm not going to plead to something I didn't do, no matter how easy it is. Mm-hmm. So we geared up for trial number 2, and we tried it, and got a very different result this time. And I've been doing this for coming up on 26 years on both sides, and I got to tell you, it was one of the sweetest victories ever because I'd been fighting for this guy and felt like I was just tilting at windmills or shouting at the wind for the better part of 4 years, and finally a jury heard me.
Wow. So you got the 2-word verdict.
Yes.
And what went through your mind when you heard it?
Thank you for giving him his life back.
Well, thank you for fighting for him.
Well, he deserved it. He's a good guy. I like him a lot.
What do you like about him?
He's kind of got a quirky sense of humor.
You liking a quirky sense
Yeah,
of humor?
I know. It's stunning, but
Can't see it.
He's got a quick wit. Even though his body is failing him and he's got the shakes, his mind is still very sharp. Mm-hmm. And he can tell a good pun. And he's just very straightforward and matter-of-fact about things. And I like that kind of honesty. There's really no middle shades of gray or anything like that. Things are very black and white. This is right, this is wrong, this is what you do. And how do you not like to fight for a person like that is the best that I can say.
So if I ever get arrested, you'll fight for me because I'm very straightforward?
Absolutely. Hopefully the check will clear. No.
No, I'm an assistant public defender. It will not.
I don't know. Maybe we can work it off in another way. There are creative ways of doing things. I've had doors replaced.
So did you talk to this jury?
I did. Interestingly, we had 4 lawyers on the jury panel.
Okay, so that's scary.
And, well, 3 of them sure were. I think I know this is tongue-in-cheek, but I think 2 of them may have been Nazis. I'm not sure. They seemed just very, very dogmatic about following the rules, and I didn't like the way they answered things. So I had already decided very early on, before they struck themselves for cause, okay, you guys are out of here. But one attorney in particular, and of course he wound up being the foreman of the jury, and then I find out after the fact that he's best buddies with Wes Rucker. But
I'm sure he's heard a few stories.
a little bit. But this particular gentleman, when I very early in my voir dire asked a question about general criminal law, one of the Nazi lawyers completely missed it and got it wrong. And this guy, it sounded like it was straight out of a Barbary brief on criminal law preparing for the multi-state. And I was just like, man, good answer. And just the way he did it seemed like he was genuinely interested in criminal law. A lot of it was body language, but the sincerity in the voice, the way he sounded, that kind of thing. And I'd leaned over to my trial partner, and the other thing that had occurred to me was I said, look, with the first jurors, we had 4 who understood their duty very well.
Correct.
And we had 8 who not only didn't understand their duty, but also were prejudiced against us because of the whole kid thing. So I said, you know, I bet you if we leave this guy on there, he's going to bring some of our outliers back to center, and he's going to have remind them this is our duty.
To follow the law.
To follow the law.
And that makes the jury charge very important too.
It does.
Well, it's always very important.
But he wound up not only making it on the jury, but as I suspected, because the few trials that I've had that attorneys actually wound up on the jury, they always wound up being the foreperson. So I was, when the state didn't strike him, I was kind of doing the happy dance, thinking that that little investment is going to pay off at the end of trial. And it totally did. So much so that when we were talking to the jury afterwards, and they were saying, well, we were wondering if we were allowed to take it out on your client because you were just such a jackass sometimes.
I really can't imagine you being anything of the sort. So.
Well, then you just have not been paying attention, have you?
So what is it that you potentially did that they didn't appreciate?
Some of it was being just very aggressive. And some of it was really catching people in missteps. One of the fun things, I told you social media became relevant with Mama, particularly in doing her backstory on things. She had a very mostly publicly available Facebook page. And a lot of people don't fill out or even make shareable that whole section about books I've read, television shows I've watched, and all that kind of thing. But it was interesting to note that prior to her testimony, it showed that she had been a fan of, you know, the First 48, some of those kinds of things, true crime shows from 10 years ago, which really wasn't so relevant. But 7 years ago, i.e. right before these allegations were made, and right as she's finishing up her educational, yes, thank you, that was skipping my mind.
Her educational
pursuits
that she only took an interest in after these charges had been filed.
There was a book that I forget the title of, but it was essentially a handbook for how I was able to survive my childhood sexual abuse, which was the equivalent of the anarchist cookbook for how to frame somebody for child sexual assault.
Wow.
And get this, after she finished testifying and left the witness stand because I hadn't paid attention to it beforehand, it disappeared. Now, I don't know about you, but that sounds an awful lot like destroying evidence, potentially, in the middle of trial. Fortunately, my client's relatives had been Johnny on the spot and paying attention to her Facebook page, and they're like, Shannon, you ain't gonna believe this.
Whoa.
So we took a whole lot of screen grabs, and then when she was being called to come back to the witness stand, it mysteriously reappeared.
Whoa.
But here's what's crazy. We wound up having to take a lunch break after I recalled her. They reappeared within 2 minutes. I was able to get screen grabs to show that it wasn't here, and then as soon as she was allowed to go into the witness room, it reappeared.
Oh my goodness.
So I'm putting all these screen grabs on there showing, look, she's lying to you.
Oh my goodness. Right
Now,
there in the middle of testifying.
Now, the jury didn't find that as persuasive. Some of them thought that I was grasping. But the witness that I sponsored that through was my client's sister, who is just such a great lady. Total salt of the earth. She would even tell, she was the kind of witness that would tell stuff that hurt her just because it's true. And she was the one that I put those things on through, and the jury just ate her up. They loved her. Me, they were like, why are you wasting our time on all that stuff? I was like, well, I was getting it in through her. You didn't believe her? Well, yeah, we totally believed her. It's like, there you go.
That's your point. Oh, wow. Okay, so I think you also bring up another point that's rather relevant. They hated you for being too aggressive.
And that's what got kind of interesting. Another reason for keeping the lawyer on that paid off in the end was he just goes, whoa, 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 whoa. You understand that that's his job, right?
But they don't expect, was the state, I won't ask you to say who the state was, but was the state at any given point aggressive?
Yes.
And so did they make that same comment about the state? Was he some sort of wacko donkey?
Well, they were more aggressive at me than they were at any of the witnesses in particular.
But aggressive is aggressive, so they didn't have a problem with the state being aggressive.
If they did, they didn't say it.
Okay.
But they did, a number of jurors commented, hey, you were too aggressive on this thing. But again, we go back to the foreman and he goes, hold it, folks. You get what his job is, okay? Those guys over there, they got to prove something happened. This guy doesn't have to prove jack. All he has to do is make sure that they can't prove their case. And put yourself in his position. Do you want somebody that's just going to lay back and take it? Or do you want somebody that's going to be out there fighting for you? And like the light bulb went off in their heads when they heard it from him. They were like, oh! So again, that decision to leave him on paid off on many fronts, because the people that were taking issue with my being aggressive and going after the cop for not investigating thoroughly, not checking out this record, making stuff up, going after the complainant for changing her story over time, going after Mama for her rather obvious motive, because all those things lined up together. Anyway, they got it, but it took one of their own to say that.
One of the things that I recall earlier is you were discussing your client's frailness. Did that go towards your defense in any way, especially as it concerns maybe because the size of the complaining witness?
That was part of it. The state had introduced some photos from about this time. The complainant had been heavily involved in junior ROTC at her school. She was like a top cadet, was very athletic, and the side-by-side picture of them, because even though my client was still able to stand and walk at that point in time, he had already been treated or had begun seeking treatment because he's like, these shakes just aren't right. He did have a bit of a pronounced hunch to the way he stood upright, and she just towered over him. And part of my whole thing in having a hard time believing that this actually occurred was, okay, you're saying it happened in a vacuum. There was no lead up or intro to it. It's just one day, boom, Dad has sex with me. And by the way, Dad, we never mentioned anything about his shakes. And she mentioned trying to be able to fight him off. And I'm going, wait a minute, little Miss Athletic that outweighs him by probably 30 pounds at this point, who's taller than he is, more muscular, and oh yeah, by the way, doesn't have Parkinson's, can't fight him off. It just wasn't adding up for me. And that did go into my defense. I mean, being able to hold it up and just say, are you kidding me? She can't fight that off?
Did the jury consider that?
What they
I
found,
guess what I'm asking is, what did the jury focus on in terms of saying not guilty?
They too had a hard time with, not as hard with the 1 time versus 4 times, because the state tried doing the Jedi mind trick. Oh, well, you have to prove it once. It's not necessarily reasonable doubt if you don't believe the other ones. You know, that kind of garbage. But they said they thought that Mama was a snake. They didn't believe a word that came out of her mouth. So maybe the Facebook things did help out. They just couldn't pinpoint and put it on their finger. As far as the complainant, they too had a hard time with the whole issue of just out of the blue one day that it happened. But what they really said did it for them was that my client testified in his own defense, and they just felt that he was so sincere with how he testified, what he testified to, the fact that he still loves his daughter, that they couldn't wrap their minds around this thing happening. You know, if it hadn't happened, wouldn't he have said, oh, I can't stand her? But no, he stayed true, and he was like, no, she's my daughter. I'll always love her. I think her mom put her up to this, and I'm not going to fault her for trying to keep Mama happy. I'm just very sad that this is how it went down. Yeah. And I think that just really struck a chord with the jurors, that they found some truth to hang on to and then realized what their oath was.
Did you ever hesitate about putting him on the stand?
No. We called him in the first trial, so it's not like it was any secret what he was going to testify to the second time around. The only thing that I really changed the second time around was I did ask some peripheral questions about other things that had been said or that had been brought up. And the main reason that I did that was because the first time that I tried the case, I tried stealing somebody else's idea. I mean, let's face it, all we do is plagiarize every other good lawyer's great ideas that work out. And I tried to do did you do any of the stuff she said? And then pass the witness.
We also plagiarize things that don't necessarily work out.
That's true. And in that trial, it did not work out because by asking more questions, I was at least able to humanize him so that they could see more of him as a person before the state tried crossing him on stuff. So they got to hear him tell his story instead of just the very short no from me before he starts getting crossed. So that worked for that other famous attorney. It did not work for me. It may work for me at some point in the future, but I'm going to keep playing with things that do work for me.
What's your biggest takeaway from this one?
Never give up. Never give up.
You sound like Eric Davis. His favorite thing is keep fighting.
Well, there's a meme out there that I think when I switched phones I lost. It's the pelican that's standing there and his big old beak is hanging down, and that's because it's got a frog body in there, and the frog's arms are hanging out of the beak, choking the pelican to keep from being swallowed, and it says never give up.
Oh, I love it. I love it.
And that's kind of the way I feel, is particularly in this job, okay, go ahead, keep hitting. Watch me not, and I don't know, maybe that's why Captain America is my favorite superhero, I don't know.
Is that the meaning behind the tie?
That is definitely part of it, yes. The other part of it I can't say on community access TV, so we'll leave it at that. But no, I mean, Think about the movie from 2011. You know, he's getting his butt kicked before he gets the formula, and he's like, I can do this all day. And that was sort of his character arc. And I kind of feel the same way on that. I mean, he was a guy that I could really get behind and fight for, and I wasn't going to quit. And I didn't quit, and now he is home free.
Well, congratulations.
Thank you.
We're very happy for your client. So I'm being told that we have 6 minutes.
Wow, that flew. Okay.
I know, right?
Never tell a lawyer what a time limit is. Okay.
So here's what I have for you.
Okay.
I heard that I should ask you about a judge believing that you were gay.
All righty then.
Can you tell this story on public access TV?
All I can really, if it's the story I'm thinking of, which maybe means that my gaydar is just broken, and everybody thinks maybe I am married to a woman. I love her very much. She may be watching right now. She's my paralegal. If it's who I'm thinking it was a very odd conversation in open court.
Yeah, it's this story. Yes.
Okay, and somehow what happened was, we got on the topic of fitness and working out and all those kinds of things.
So just to be clear, it was a male judge,
Yes,
right?
it was.
Okay.
And he said something like, well, if, you know, one of these days your metabolism is going to slow down, and when it does, you got to look out, because right here is just impossible to get off. And I just went, thanks, Judge. I appreciate that.
What did that have to do with your sexuality?
Apparently, I must be thinking of the wrong story, but that particular judge happened to be gay, so.
Yeah, that's what I'm thinking of.
But if it's the other, I've fallen asleep.
Has this happened a lot? Like, you've got more than one of these stories?
Well, not judges, but I can say that my roommate in law school gave me grief because I came home from the grocery store one night and I said, I got hit on by a male couple. They wanted to make a threesome.
A throuple.
Yeah, and then I got asked, because I'm an Aggie, I got asked to go talk to the...
You're an Aggie?
Yes.
And you admit that openly? You
Probably.
realize you have the right to remain silent.
Yes, I do. I just lack the capacity sometimes. But I got asked to talk to the A&M Pre-Law Society in College Station, and one of the pre-law folks started hitting on me, and I'm like, yo, dude, not my thing, sorry. I got home, I told my roommate, he was like, twice in 1 week. What are you throwing out there, dude?
I mean, maybe. But yeah. We're down to the last 4 minutes. I don't have any more questions for you.
Okay. Were we that boring we didn't have any callers? I was kind of surprised.
I didn't run the key. I'm sorry. I didn't know you wanted it. I'll run it. Here it is.
Let's see. Oh, I didn't know. So that's part of the thing. Like, Murray just said, hey, Jackie, can you host today? And he left me with no instructions.
Well, that was because we were party to that same text thread that said, hey, let's put Shannon on.
Actually, there was a text thread before that.
Oh, okay. I didn't get the preparatory text. Okay.
But yeah, I was like, yeah, let's bring Shannon on, because, you know.
Well, I appreciate the props.
So it's a major win. And I'm so happy because, your client had so much going on, and it's so easy to just cave, right? Between time and pressure and the constant having to show up and just wait. A lot of people just say, I want to be done with it. And your client said, no, I'm going to keep fighting. Well,
Let me fast forward to the unhappy part of the ending of this thing. And that is that last week I unsuccessfully argued for his expunction. The state of Texas, in their infinite wisdom, decided to say, no, we could still file another charge if we wanted to, so we are opposing this expunction.
And that goes back to the great decisions that the district attorney's office is currently infamous for.
So, but to my client's credit, because I told him the case law was so very unfavorable for overturning that decision, he still wants to fight, and fight we shall.
That's beautiful. I don't see anything about callers. We're down to our last minute. So I want to thank you for coming on the show. I want to thank you for fighting, right? Because defense lawyers particularly get a really bad rap. And it's easy for the state because they wear the white hat. I want to thank you for having such a great attitude during the fight, because I run into you in court all the time. And I want to thank all the viewers for watching.
Thank you, Jackie. I appreciate being here.
Next week, y'all will have Murray back. Or at least he won't be on vacation trying to get away from me.
Well,
Good night.
Good
good
night.
night.